We have a very busy morning. We've got some visitors here. We've got to take care of one misdemeanor matter before we start our landlord tenant docket. And we've got a lot of people already in the waiting room. So just get right to it. Thank you for saying good morning. Planned to come in a little earlier, but I got sidetracked. Still beautiful summer in Michigan, even in Holland. I got a long distance message from here in the courtroom. So let's get right to it. As I said, I've got a number of people in the waiting room. All right, before we begin our criminal docket, we have to deal with before we start our landlord tenant docket, I have a misdemeanor matter I have to address. So I beg your patience. Attorney Jay Allen isn't here yet anyway, so let's address this matter. People versus John Elmer Fox Jr. File number is 24787SM. Mr. Fox is here with his, go ahead and have a seat, with his lawyer, Luke Knopfinger. File 24787SM is a larceny less than $200 charge. File 241288ST is a driving suspended charge. Mr. Fox was here. He got picked up on a bench warrant. Judge Pattison was gone, and I dealt with Mr. Fox at that time. It was a Friday afternoon, September 6th, late in the day. He'd been picked up on these matters, and I had to do the arraignment because Judge Pattison was unavailable. And Laura, could I have some register of actions? Anyway, so we dealt with the matter. I gave him 2 PR bonds, and he appeared here today. Mr. Fox represented that he was working at Parma Tube. So we called Parma Tube to confirm that he was actually employed there. And I said, well, the worst I can do, I guess, is be wrong. So no one was there late in the Friday, so we left a message. Parma Tube called back on Tuesday and said, John Elmer Fox doesn't work here. He never worked here. And I feel bad about it.
I walked off the day you let me out.
What's that?
I walked off out of the day you let me out.
So well, they said you weren't working there.
I was. I don't know why they say that.
All right, but you're not working there now?
No, Your Honor. I was having called 2 days ago.
Stop. Stop. I believe what they said is you never worked there. So we're going to call and reconfirm that. And but my inclination is to revoke your PR bonds. I granted the PR bonds based on your false representations of employment. So I don't believe you're working there on September 6th or 5th or 4th or 3rd. So your contention is that you had worked there up till September 6th?
I only worked there 2 days, not even 2 days. And then when I went to jail, I got out. I went to work. They said there was no reason for me. I was working I was staffing for them.
Luke, I'm sorry to tie up your time and mine. I've got a bunch of other stuff to do. Luke, have you got other cases to deal with?
I do, yeah.
All right, put Mr. Fox in the lockup. We'll deal with him when we have a more convenient time. Stop.
Judge, what is the basis?
His basis is false representation to me that he was employed when he was not. So I granted a PR bond. And I'm about to revoke the PR bond. I find he's in contempt for lying to me about his employment in my decision to set his bond.
All right, I'll be honest.
Yes.
I was not working, Your Honor. but I have good reasons why this lied to you.
All right, stop. All right. The
Okay,
PR
reject.
bond is revoked in each case. One was 500. I'm gonna reinstate two $200 cash or surety bonds in each file. One was 500, one was 250. So the PR bond is revoked. The defendant was in contempt for providing false information to the court and continuing to lie to me this morning. So you got two $200 cash or surety bonds.
Got it.
I don't say anything else, or I'll make
May
a
I?
$10,000
May I,
cash or
please?
surety. But I don't want to. You're even lying to me this morning. Just
That's
stop.
why I
Just
corrected
go.
myself.
All right, and I appreciate that. That's why I reduced these to $200.
May I ask you one thing?
Don't make it any worse. Just
I'm not
Carl, would you
trying to.
please take him back?
I'm not gonna do that.
That's just go. Just go.
Judge, I just have to say too, I was a little unprepared for this. I didn't know this was coming. Just a simple notice and hearing. I don't know the bond revocation court rule off the top of my head. I don't know if the court has the ability to hold them in contempt for something. I wasn't present for that. I feel a little flat-footed at this point. If I could have a chance to simply review the court rule, and talk to my client.
Certainly. What
About
Mr.
it.
Reed did is he filed a motion for rehearing. He got this PR bond based on false representations to the court. Then he continued to lie to me this morning until he finally came clean on it. So he's going into custody. You can file a motion for rehearing or appeal or something, but right now the bonds are amended to $200 each, cash or surety. I apologize. I came in and announced what the deal was to the people in there. Apparently you weren't there yet. So Andy knew and Luke knew, but apparently they didn't say anything to you. You weren't here yet. But Mr. Fox, you go with a court officer. I'll do an order to that effect, Luke, so you can deal with it.
Sure, I apologize. Never lied to you before. I don't know why I did.
Yes, thank you. Well, if somebody will bond you out, you can deal
Ain't
with it.
no one bottom me out, man. I have nobody out there. I ain't even talking to my dad anymore.
What we just witnessed was a courtroom moment that cuts deeper than most. Tia Jo Brooks stood before the judge on a domestic assault charge against her husband, Austin Brooks, a man this court already knew well. Austin had been through the system himself, completing over a year in a domestic violence program where the entire family participated in counseling. He was named Employee of the Year. Progress was real. But then came the relapse, alcohol took hold again, and with it, every problem the family had fought so hard to overcome came rushing back. Tia's attorney laid it out plainly. For roughly 20 years, she had put everyone else first. Her husband, her children, herself, dead last. When the situation boiled over, she found herself on the wrong side of the law. But here's what stood out. Nobody in that courtroom, not the defense, not the prosecution, painted this as one-sided. The prosecutor himself acknowledged that Tia had been on the receiving end for years before this incident. This was a family in crisis, not a simple case of black and white. The judge granted a domestic violence deferral, placing Tia on 12 months of probation with the possibility of completing it in 6. No additional jail time beyond the one night already served. The no-contact order was lifted so this married couple could begin rebuilding. And critically, Tia was already doing the work, voluntarily hospitalizing herself, attending counseling twice a week, getting her children into therapy, and starting a new job the very next day. This case is a reminder that domestic violence doesn't always look the way we expect. Sometimes the person standing before the judge has been carrying wounds of their own for decades. The court saw that here, and responded not just with accountability, but with a path forward. If you found this case as eye-opening as we did, hit that like button. Drop your thoughts in the comments, And subscribe for more real courtroom breakdowns, because justice never gets old.